Well, good afternoon, all. My name is Richard Hunt. I'm the director of the Center for Legislative Archives, and it's my pleasure to introduce David E. Kyvig, Distinguished Research... Kyvig, sorry.
That's all right.
Kyvig.
Nobody knows Norwegian names.
Distinguished Research Professor Emeritus at Northern Illinois University. Dr. Kyvig is one of the foremost experts on the history of amending the Constitution, so it's most appropriate that he's here at the National Archives, the keeper of the original Constitution and the ratification documents for the 27 amendments that have been added to it. In 1997, Professor Kyvig won the Bancroft Prize for Explicit and Authentic Acts, amending the U.S. Constitution 1776 to 1995, where he explored the significance of Article 5, one of the most overlooked clauses of the Constitution, and how important it has been to the history of the United States. He has also written or edited 11 scholarly books, including Repealing National Prohibition, Unintended Consequences of Constitutional Amendment, and The Age of Impeachment, American Constitutional Culture since 1960. Today, Dr. Kyvig will talk about the offspring of our own choice, amendments in constitutional thought and practice. Dr. Kyvig.
Thank you. I should also recognize Richard McCulley, who is on your staff, who organized this program and unfortunately is off ill at the moment. Hope he's back with us soon. And he asked if this session could be videotaped. I don't think planning to watch it on videotape himself, but just a suggestion of how foresighted he is. Anyway, I've spent most of my career examining the Constitution and the process of amendment. I started because I had a youthful interest in alcohol and how it came to be banned and how it became the only constitutional amendment ever adopted to then be repealed, which I was entirely in favor of. But what I didn't really understand when I began that dissertation was how the fact that it was a constitutional issue shaped the whole matter. And by the time I had finished repealing national prohibition, I had become somewhat acquainted with an issue that I would devote the rest of my career to. And I'm still working on, though not at the pace that I worked when I was young, energetic, and foolish. Well, at least young and energetic. I probably still am foolish, but we'll leave that for another time. George Washington devoted a good bit of his farewell address to the amendment process. He had presided over the Constitutional Convention. He had not spoken very much at the Constitutional Convention, but he had been there and been very alert throughout the proceeding. He then became, of course, the first president and occupied the presidency when the Congress passed the first 12 amendments to the Constitution, and the then states ratified 10 of them. And he'd had a lot of time to reflect on the amending process. And this is what he said in his farewell address. To the efficacy and permanency of your union, a government for the whole is indispensable. No alliance, however strict, between the parts can be an adequate substitute. They must inevitably experience the infractions and interruptions which all alliances in all times have experienced. Sensible of this momentous truth, you have improved upon your first essay, the Articles of Confederation, by the adoption of a constitution of government better calculated than your former for an intimate union and for the efficacious management of your common concerns. This government, the offspring of your own choice, uninfluenced and unawed, adopted upon full investigation and mature deliberation, completely free in its principles, in the distribution of its powers, uniting security with energy, and containing within itself a provision for its own amendment, has a just claim to your confidence and your support. Respect for its authority, compliance with its laws, acquiescence in its measures are duties enjoined by the fundamental maxims of true liberty. The basis of our political system is the right of the people to make and alter their constitutions of government. But the Constitution which at any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. The very idea of the power and the right of the people to establish government presupposes the duty of every individual to obey the established government. That was Washington's view of the importance of Article 5. Article 5, the amending article of the Constitution, has been relatively little used but seldom out of the headlines. It's been 27 years since the 27th Amendment to the Constitution was adopted. It's been 43 years since the 26th Amendment. The 27th Amendment is rather unusual for our most recent constitutional amendment because it was written by James Madison. It was one of the first 12 amendments adopted by the first Congress. And it took 203 years for it to be ratified by enough states to take effect. I'll return to the 27th Amendment if there's time. But it's been 43 years since the 26th Amendment, the 18-year-old vote amendment, was ratified by the states in the early 1970s. One thing that is evident is that people have very short memories about the constitutional amending process because we have had any number of amendments proposed this spring. And one wonders if Article 5 is very well understood because there seems to be this sense that amending the Constitution, no real problem. the fact that we've got a former Supreme Court justice who just last month, or now I guess it's more than a month ago, published a book called Six Amendments, proposing a series of amendments to overturn Supreme Court decisions where he was on the short end of the decision. John Paul Stevens suggests that even those who should know about the constitutional amending process may be a little fuzzy on some of its details. And those details are vitally important. Article 5 says that there are two ways to propose amendments. The first is for 2/3 of both houses of Congress to agree on an amendment and send it to the states. The second alternative is for states, 2/3 of the states, to petition for Congress to either propose the amendment or to call a constitutional convention for the proposing of amendments. In either case, there has to be ratification by 3/4 of the states. And that can be achieved by whichever procedure the Congress stipulates. The commonly used alternative is for state legislatures to ratify the amendment. But the alternative is for states to call conventions where the people would select delegates to a ratification convention. That procedure has only been used once. It was used in 1933 because the people who opposed prohibition didn't trust the state legislatures who had ratified the 18th Amendment, taking their refreshment away, to ratify the 21st Amendment, giving legal refreshment back to them. And they insisted on the convention process being used. It took only 10 months from the time that Congress accepted the alternative procedure for sufficient states, actually 39 states, more than sufficient, to hold conventions and to repeal national prohibition. The 21st Amendment was one of the fastest amendments ever achieved. 73% of those voting in state elections voted for candidates sworn to repeal. It was a clear indication of a consensus of the American people behind amending the Constitution. There's been a lot of talk that the Constitution is too difficult to amend because we've only had 27 amendments. But the founders very clearly wanted the Constitution to reflect consensus. And so they set the highest standards of any matter that was addressed in the Constitution, the highest standards for amendment in terms of popular consensus. We can elect a president with less than a majority. We can ratify an international treaty with 2/3 of the Senate. We can do almost anything with a smaller degree of consensus than amend the Constitution, where we need 2/3 not only of the Senate, but simultaneously of the House, and then 3/4 of the states. And I would submit that one of the reasons our government has been as stable as it has been, despite the frequent alteration of popular majorities, is that our Constitution was designed for stability. And within that framework, there is no particular formula for amendments. They can be what the Congress and or the people decide at the moment. Keep in mind that the Congress of the United States in 1789 decided to submit 12 amendments to the states for ratification. We know the 10 that were first ratified as the Bill of Rights. Separate amendments. By the time we get to the Civil War, the designers of the 14th Amendment are nervous about whether the states will pick and choose whether to ratify their various proposals for reuniting the country and dealing with the problems of the Civil War. And so in the 14th Amendment, 4 very different statements are all combined into one amendment that is given to the states, and the states of the South not given a completely free exercise of choice, but told, you want to get rid of the military occupation, you better ratify this amendment. And they have to swallow the 14th Amendment whole to get back into their normal functioning role in the Congress. Since then, most amendments have not been as complicated as the 14th, but we have continued to play with the amending process. The Supreme Court has several times been asked to address issues that are not specifically dealt with in Article 5 of the Constitution. Does the President have any role in the amending process? In the 1790s, that question was asked the Supreme Court, and the Supreme Court said no in Hollingsworth versus Virginia. no presidential role whatsoever. Lyndon Johnson in the 1960s certainly wanted to play a role in the amending process and ignored the suggestions from his own Justice Department that that was a little over the top and didn't have any legal support. So he ginned up a document that essentially said he was observing the process of sending the 25th Amendment to the states for ratification. Had no meaning whatsoever and hadn't for 200 years. But that was Lyndon. In 1917, the state of Ohio, recognizing that they were soon going to have to deal with prohibition, the state legislature passed a resolution saying, before our state legislature can act on prohibition, we want to have a state referendum on whether the public wants state legislative action on prohibition. And sure enough, the state legislature went ahead and ratified the 18th Amendment, the Prohibition Amendment, and people called for a referendum. A referendum was held, and by a narrow margin, the people of Ohio said, no, we don't want prohibition. We don't want this 18th Amendment. And so the case went to the Supreme Court. Had Ohio ratified the 18th Amendment or had it not? And the Supreme Court of the United States said, according to Article 5, the Congress sent the 18th Amendment to the state legislatures, and the state legislature in Ohio has acted in accordance with that requirement. And so the public referendum that said otherwise has no standing whatsoever. It became a part of the campaign for repeal, a clear argument that this amendment was put over on the good people of Ohio against their preference. And the same argument cropped up in, surprise, surprise, other states which hadn't had a referendum and still could argue that it had been passed against their preference. The Prohibition Amendment caused all sorts of strange things to happen. Warren Harding, senator from Ohio in the 19-teens, was caught on the horns of a dilemma. He had lots of Republican supporters in Ohio who were also supporters of prohibition, Ohio being the origins of the Anti-Saloon League of America and one of the origins of the Women's Christian Temperance Union. What was he going to do? If he voted against prohibition, he was going to lose a lot of support among his so-called base. If he voted for prohibition, he was going to cut off one of his own personal favorite recreations. He came up with a brilliant solution. I'll vote for the 18th Amendment he said, but only if we put a time limit on ratification. There had never been a time limit on constitutional amendment ratification. The temperance issue had been discussed for decades. And he said, if we hold them to 5 years, they'll never get enough state ratifications to adopt prohibition, and the issue will be gone. Well, he negotiated with the Anti-Saloon League, and they finally decided on 7 years. The amendment took 13 months to be ratified. Whether that's a fair assessment of Warren Harding's political skill and judgment, I'm not going to touch. But the Supreme Court was asked whether that was a legitimate restriction on the amending power, or whether that had somehow compromised the 18th Amendment altogether. And in 1922, the court said time limits were reasonable. And they have been frequently used since, but they're not required. They're not part of the original Article 5. And in the 1980s, a young man at the University of Texas, having been given a freshman political science paper to write, decided that that was the year that the Equal Rights Amendment was being defeated, or at least it failed to be ratified, and was, because it was time limited, was expiring. He wrote a freshman paper saying, you know, Mr. Madison's Second Amendment, which prohibited Congress from raising its own pay, is not time limited and could still be ratified. His freshman political science professor thought it was the craziest idea, but it had been a well-written paper, so he gave it a C-. Well, Jeffrey was distressed, and he had one of the first generation of desktop personal computers. He wrote to every member of every state legislature, sent him a copy of the paper, said, look, you can still ratify this amendment. And there were a lot of state legislatures in the 1980s that were upset that Congress was raising its pay so generously. And bit by bit, Mr. Madison's Second Amendment got ratified. And in 1992, it achieved sufficient state ratifications that it was certified by the Archivist of the United States as having been ratified, and Congress scratched its head and said, well, we could declare this null and void, because the Supreme Court had always said that acceptance of a ratification was a political question and was up to Congress. But Congress, wisely, I think, decided in 1992, this is not something that we want to get into, because we're just going to stir the pot of anti-congressional feeling if we say, no, you can't limit us from raising our own pay. And so they accepted Mr. Madison's Second Amendment after only 203 years. So time limits are a sometimes thing. And I think what we learned in 1992, because Senator Robert Byrd stood up immediately after the 27th Amendment was accepted and said, we ought to wipe out these other amendments that are still on the books that were passed by Congress. And Congress loudly yawned and did nothing with Mr. Byrd's resolution. Mr. Madison's First Amendment is still out there. And Mr. Madison's First Amendment was a formula for expanding the size of the Congress as the country grew. Because as Mr. Madison and many of his contemporaries said, if we're going to have a democratic republic, we've got to keep the relationship between the representative and the number of people represented at a reasonable ratio, so that the people can be in touch with their representative. And the formula was open-ended. The formula would, if one more state had ratified in the 1790s, be controlling now. But since they didn't get that one more state, Mr. Madison's amendment failed at the time, but it is still available for ratification. It would take 27 more states now to ratify it. But if we ratified it now, we would have a Congress not of 435 people, which has been the case for the last century. We now have constituencies of 720,000. They're the second largest constituencies of any alleged democratic republic on the planet. Only India has larger constituencies than the United States. We would have Mr. Madison's Second Amendment, which would have constituencies these days of 200,000. We would have a Congress of 1,625. We wouldn't have these huge constituencies that can be gerrymandered as so many are now, that distort the democratic process. We wouldn't have congressional campaigns conducted only on television, because that's the only way you can reach 720,000 people in a reasonable amount of time. So the fact that constitutional amendments pass or don't pass by a narrow margin is not just a concern for the women of America, who saw the Equal Rights Amendment fall 3 states short of ratification, but all of those who saw Mr. Madison's amendment fall 1 state short. I've talked probably long enough. I've got plenty of other things that I'd be happy to talk about, but why don't I quit at this point and open it up to questions from the floor?
That'd be great. Well, let me start with a question. Is Article 5 and the ability to amend a constitution unique or rare among constitutions?
The American Constitution is the oldest functioning constitution on the planet. I'm happy to say that Norway is the second longest functioning constitution on the planet. But since the amending article has proven so successful, it has been modeled in many of the more recent constitutions, most, I think, of the more recent constitutions.
Were the states added as well?
Oh, yes. Oh, yes. Yes, indeed.
Questions?
I guess what's so interesting and provocative about your comments, David, is the issue of change that underlies it. And that is, you began with the long quotation from Washington, which suggests that Washington and that generation was change averse. They had made one big change in dumping the Articles of Confederation. Now they were onto a new document, and change, if it came, was not going to come easily. Or as you pointed out, they were very much in favor of stability. But the question is, with Article 5, were they concerned about changing the document or something that was already in the document, or were they concerned about changes that were not covered by the document, but rather broader changes in society and how those were to be handled?
That's a very good question, and I think I would start to respond by saying they were not convinced that they had answered every question that a constitution should answer. And in fact, several states proposed a series of amendments as essentially the price of ratification of the Constitution. Madison worked from the proposed amendments that came from half a dozen different state ratification conventions in putting together and boiling down the list of amendments that became the Bill of Rights. There were issues that the Constitutional Convention had not been able to agree on. As far as the Bill of Rights, the Constitutional Convention had simply believed that those were things for the states to deal with, not for the federal government to deal with. And so they didn't see the need to add those to the original document. But the state ratifying conventions did see those as critical issues for the federal government to, in many cases, be confined by. And so there was an acknowledgement that there were social issues that the country wasn't ready to deal with in a definitive way. But Washington, Madison, Jefferson all knew that slavery would have to be dealt with at some point. And one of the patterns that emerges over now more than 2 centuries is that amendments come in bursts. We had the burst of amendments in the first Congress, the Bill of Rights. Except for a couple of small technical changes, the 11th and 12th Amendment, we don't have any amending until after the Civil War. But then we have the 3 Reconstruction Amendments that Charles Beard, the great early 20th century historian, called a second American Revolution for the range of and substance of changes that it made to the American Constitution, and really quite fundamentally changed it. Then we don't have any amendments for another 40 years, and the general attitude at the end of the 19th century was that, well, maybe we can only amend the Constitution when we've had a war, a civil war. And some states really are not fully equal participants in the process. But there was a buildup of discontent with the Constitution, especially after the Supreme Court, in a highly questionable decision in the 1890s, said an income tax was unconstitutional. And throughout the country, the choice of United States senators by state legislatures was becoming very controversial. And then all of a sudden, we get another burst of amendments. We get the Income Tax Amendment, number 16, in 1913. The same year, we get the direct election of senators. And then, lo and behold, we get 18, of which I have spoken previously, and 19 women's suffrage, all within less than a decade. We get the repeal amendment 14 years later, and we get a very interesting amendment that reshapes Congress, the 20th Amendment, that moves up the inauguration date of the new president, the start of the new Congress, and does some very interesting things, at least to me and maybe 12 other people on the planet, that I write about at dreadfully extended length in my amendment book. So we get a bunch of amendments, and then not much until the 1960s, when we get another burst of amendments. So the fact that we haven't had, depending upon how you count, an amendment for 27 years or 43 years if you associate the 27th Amendment with the first Congress, doesn't surprise me. But yes, I think the plan was that there would be need for constitutional change as the country fundamentally changed, as clearly it did in the middle of the 19th century, and with the coming of modern industrial urban society in the early 20th century, and then with the post World War II changes in our society. It was a far-sighted plan.
You've got a nice catalog of, and I'm glad you made that distinction. Fundamental change to the structure of government that was established by the founders versus things like prohibition, which are totally unrelated. And isn't the thrust sort of expansion of government power? Because like the 19th Amendment, some states had granted the franchise to women, and then the feds decided that all states would have to do it. So could you sort of distinguish between those two categories? I mean, the 17th would be, the Constitution said legislatures will choose senators, and then they change that to direct election.
The arguments for each of the amendments were intimately entwined with the substance of that particular amendment. What I think has to be kept in mind is that while there were parts of the country that were not as eager as other parts of the country for the fundamental changes that were involved in these amendments, ultimately there had to be a very high degree of consensus. 3/4 of the states had to agree. Now, one of the things that I find very interesting about the Equal Rights Amendment is that there was a segment of the country that was clearly out of step with the bulk of the country in terms of women's rights. And because of our emphasis on the power of states in the constitutional revision process, what we end up with are 15 states saying no to equal rights for women, but it's a much smaller portion of the population reflected in those 15 states that say no. It's mainly the states of the old Confederacy and the Mormon West, the Mountain West. And the bulk of the population in states from California to New York are highly supportive of the Equal Rights Amendment. Now, there's one exception. There's the state of Illinois, my former residence. The state of Illinois in the 1960s passed a measure saying that for the state legislature to ratify a constitutional amendment, it had to do so by 60%. This was a internal decision of the state legislature. And in that case, Illinois several times passed the Ratification Act by 58, in one case 59%, but never reached 60%. And for reasons that I find rather bewildering, that has never been effectively challenged. Indeed, the state Supreme Court held that that was a legitimate behavior of the state legislature. So the Equal Rights Amendment suggests to me that we have an enormously high threshold of consensus that we expect of constitutional amendments. And so by the time the 27 amendments that have succeeded have met that, that standard, we ought to have a fairly high confidence that we're dealing with what we can remember in our history but very seldom see today, a high degree of national agreement.
Could you also address the, you mentioned ELA, other failed efforts such as child labor? I mean, what other kinds of issues didn't make it?
Okay, there were 6. I've mentioned Mr. Madison's amendment. The next amendment to pass the Congress but not be ratified occurred in 1861 on the eve of the inauguration of Abraham Lincoln. The Congress of the United States passed an amendment guaranteeing the perpetuation of slavery in states where it then existed. They were trying to head off the Civil War. And believe it or not, the state of Ohio ratified it, but the amendment perpetuating slavery got no further. And we understand the alternative. I think the likelihood of that amendment coming back to be ratified, though it's still on the books, is somewhere between slim and none. I think closer to none. The next amendment to fail was the Child Labor Amendment, which was adopted by Congress in 1924, 4 years after women acquired the vote, and very clearly a response of the 67th Congress, I think it was, that women's issues needed to be taken seriously. And there was quite a bit of demand for child labor protection after the Supreme Court, in a couple of its more unfortunate decisions, had knocked down previous efforts to federally prevent child labor. By 1938, the Supreme Court had changed and essentially said labor regulation of this sort is entirely constitutional and acceptable, and the amendment, which had acquired 20, I think, ratifications, was decided not to be necessary anymore. And then the last amendment to go down without a time limit on it was the D.C. statehood amendment of 1970. And it simply ran afoul of rural Republican states who said, wait a minute, this will give those Democrats in D.C. 2 more Senate seats, and we're not going to put up with that. And so it has been defeated, not because of any particular mysterious circumstance, but simply because of the political advantage that rural states don't want to concede by ratifying the amendment.
David, we have time for one more question. Is that all right?
Sure.
I was curious, are you aware of any unforeseen consequences of the baby boomer amendment, the giving 18-year-olds the right to vote?
Well, I think it's been an amendment that was widely embraced by the Vietnam generation that felt that it was being sent to war without its own permission. Being part of that generation, I suppose I'm a little biased on this this issue, but what has struck me about the baby boom amendment is that how long it took for the 18 to 21-year-old generation to become as involved in American politics as other age cohorts. The 18 to 21-year-olds didn't come up to the same level of voter participation as their elders until 2008. And that was much slower than women's participation levels. In the first couple of elections that women were eligible to vote in, they voted at a much lower level than their male counterparts in 1920 and 1924. But by 1928, apparently drawn by the candidacy of Alfred E. Smith, urban women in particular began to vote at the same rate as their male counterparts. Why were 18 to 21-year-olds slower? I'm not sure, but that is one of the aspects of the process that somebody else is going to have to explain, because I can't. Thank you. Thank you.